Claudia. Do you think they might have settled it?
It's possible, but I do not know. The only side is one sided.
I'm going to bring them in and see if 'cause they're there with his client now. Yeah. Oh wait, it's not close to 9 yet.
Start video. Hold on. Why is the video not? There we are.
Is everybody here that we're expecting?
Yes, Your Honor, I believe so.
Okay. This is 003-2270-2021 Rancho Palisades versus Charles Hawley. Probably I'll start with who you are and who you represent.
Okay, Your Honor, my name is Jerry Carlton. I am the attorney for the plaintiff.
Okay. And Mr. Hawley, you're appearing pro se, I guess?
Yes, sir.
Okay. And this is an eviction trial. The plaintiff may either make an opening statement or call your first witness.
Thank you, Your Honor. It is a eviction for non-payment of rent. And we will call Sarah Webb to testify initially.
Okay. If you would raise your right hand and be sworn. Do you swear or affirm testimony about to give be the truth, the whole truth, nothing but the truth, stuff you got?
Yes, sir.
All right.
Okay, Ms. Webb, can you tell us your full name?
Sarah Elizabeth Webb.
And do you work at Rancho Palisades as assistant manager?
Yes, sir.
Do your duties there involve dealing with leases, residents, notices to vacate, evictions, and delinquencies?
Yes, sir.
Are you familiar with the defendant in this case, Charles Hawley?
Yes, sir.
You have before you what's previously been marked as Plaintiff's Exhibit 1. Is that a true copy of the lease with the defendant?
Yes, sir.
And does, Your Honor, we offer Plaintiff's Exhibit 1.
Any objection from the defendant?
No, sir.
All right. Exhibit 1 is admitted.
Under that lease, is the defendant obligated to pay rent on the first of each month?
Yes, sir.
And is that monthly rent $1,526.50 according to the lease?
Yes, sir.
Did the defendant default on the lease by failing to pay that rent for the period of December of 2020 through June of 2021?
Yes, sir.
You have before you what's marked Plaintiff's Exhibit 2. Is that a true copy of the ledger that shows the charges and payments on this account for the period at issue?
Yes, sir.
Your Honor, we offer Plaintiff's Exhibit 2.
Any objection to Plaintiff's Exhibit 2?
No, sir.
All right. Plaintiff's 2 is admitted.
As a result of the defendant's defaults on the lease, did you deliver a notice to vacate and demand for possession to the defendant?
Yes, sir.
And did you do that on January 7th of 2021 by delivery, posting on the inside of the main entry door of his apartment?
Yes, sir.
Your Honor, I'm sorry. You have before you what's marked Plaintiff's Exhibit 3. Is that a true copy of the notice that you delivered on that date and in that manner?
Yes, sir.
We offer Plaintiff's Exhibit 3, Your Honor.
Any objection to Plaintiff's Exhibit 3?
No, sir.
Plaintiff's 3 is admitted.
Did the defendant move out?
No, sir.
So as a result of that failure to move out, you had to file the eviction suit that was originally in Justice of the Peace Court that's on appeal here today to this court.
Yes, sir.
As of today's date, if the rent is prorated, is the amount of rent owed $10,278.43.
That is correct. Yes, sir.
And if the full amount of June's rent is awarded as the lease provides for, is the full amount of rent owed through all of June $10,685.50?
Yes, sir.
And that's rent only on both accounts, right?
Yes, sir.
Okay. And as a result of the filing of the case, the defendant's appeal, did you have to retain our law firm and me to represent plaintiff and agree to pay a reasonable fee for those services?
Yes, sir.
And so today you're asking the court for judgment for possession, rent, attorney fees, court costs, and interest.
Yes, sir.
In addition, for any money that was paid to the registry of the court by the defendant, are you requesting that the judge order the clerk to pay those funds to the plaintiff to be applied to the debt that's owed?
Yes, sir.
I pass the witness, Your Honor.
Does the defendant have any questions for this witness?
Um, no, no, sir. Yes, sir.
Okay.
Sarah, did Cola Durant discuss a conversation that her and I had of me paying the rent prior to or at the trial for this case to be dismissed and for payment to be paid in full?
Yes.
Okay. No further questions.
Does the plaintiff have any further questions of this witness?
Not for this witness, Your Honor.
Call your next witness.
Your Honor, I would like to testify on attorney fees.
Okay.
My name is Jerry Carlton. I'm an attorney licensed by the Texas Supreme Court since 1980. I have been practicing litigation, including landlord, tenant, and eviction matters, such as the one before the court today. I've handled hundreds, if not thousands, of such eviction cases. I teach seminars and webinars for the local and state apartment association on eviction and landlord-tenant matters. My work on this case has included reviewing all the facts and the documents, reviewing with the client, preparing with the witnesses for trial, preparing supplemental petition for damages, meeting with the witnesses for the trial testimony, preparing exhibits for trial, and preparing a proposed judgment for entry. My work on this case will be approximately 5 to 6 hours by the conclusion of the matter in this court. My hourly rate is $300 per hour for these residential eviction cases, which is a reduction from my commercial litigation rate of $375 per hour. I also have a paralegal, certified paralegal, who has performed services on this matter to make the cost less expensive for the client for certain work on the case. She will have approximately 3 hours of work in this case at $125 per hour. All the work that's been done is reasonable and necessary. I am familiar with usual and customary fees charged in Collin County, Texas for similar matters. Considering all the foregoing factors, plus the difficulty of the case, the skill required to perform the services properly, the amount involved, the expected result to be obtained, the nature of the relationship with the client, my experience, reputation, and ability, and all other factors this court is legally required to consider, my opinion is that these fees as follows are reasonable for a plaintiff. Through the county court at law proceedings, $2,000. Through the Court of Appeals, an additional $5,000. And through the Texas Supreme Court, an additional $5,000. Of course, those two additional levels of appeal to be awarded only if plaintiff is the ultimate successful party. I pass the witness, Your Honor.
Does the defendant have any questions for this witness?
Yes, sir. Are you expecting me to pay these fees, or you're just asking the plaintiff to?
Well, the plaintiff has agreed to pay my fees, but under the lease, you're obligated for the payment of the fees when the lawsuit is pursued. As a result of this appeal, I was hired to represent them.
Okay. No further questions.
Okay. Anything else? Any other witnesses?
No, Your Honor, plaintiff rests.
Okay. Does the defendant wish to testify or have any witnesses?
Testify, yes, sir.
Okay. If you would raise your right hand and be sworn. Do you swear or affirm testimony about to give be the truth, the whole truth, nothing but the truth, so help you God?
Yes, I do.
All right. You can go ahead and testify.
Yes, sir. So I've called in to Rancho Palisades about the current balance, which shows on my residential portal that I can access for this apartment complex to be slightly over $12,000, I believe $12,230.17. I did attempt to pay this amount this morning. However, I do not have access online to. What I'm asking at this time is to pay the amount that is due. And it sounded even better when what they said today with just the rent amounts of the a little bit over 10,000 that I would like to pay. But I would love to keep my apartment. I did speak to Cola Durant, who works in Rancho Palisades, on Friday, that Miss Sarah did acknowledge the conversation that her and I had, which was to make payment and the eviction not be continued with. And so at this moment, I'm asking you, as we come to judgment, to allow that payment so I can become current with my my apartment complex, keep my place of residence, and all parties hopefully be happy with the situation. I can say that in the prior time to this escalating to this matter, when I was a little bit over 2 months behind, I did give money orders that were that 3,400 roughly of that amount. However, they were returned to me because I did not pay the next month's rent. I do believe that was unfair at the time because it was just the first. However, that's the reason why it is escalated. I've attempted to make payment, and I now have all payment, and I would just like to make payment if possible.
Anything else?
No, sir.
You pass yourself as a witness?
Oh, well, I passed myself as a witness.
Yeah.
Like, if yes, sir.
Okay. Mr. Carlton, do you have any questions for the witness?
No, Your Honor.
Do you have any other witnesses you wish to call?
No,
No,
no, I
Your
do
Honor.
not.
Oh, sorry.
Oh, sorry.
So does the defendant have any other witnesses?
Oh, no, sir.
You
No,
rest?
Your Honor.
You rest
Yes.
your case? Does the plaintiff have any rebuttal witnesses?
No, Your Honor.
You rest and close?
Yes.
Defense rests and close?
Yes, sir.
All right.
Yes, Your Honor.
Any final argument?
Your Honor, as the defendant has not presented a legal defense, the plaintiff would request that the court enter judgment for the rent, possession, attorney fees, court costs, and interest as requested. And just for Mr. Hawley's benefit, any discussion about curing the defaults, et cetera, can be conducted outside the courtroom after the judgment is entered.
Okay. Anything else, Mr. Hawley?
I'd just like to pay the rent, sir. I'd just like to pay the rent. I would not like to pay the attorney fees and all that other things besides what I owe Rancho Palisades. Even with late fees included, I have no problem. And that's what I would ask at this time for judgment.
Well, basically, I don't have the authority to order them to take your money. All I can do today is grant them a judgment for the relief they have sought. Y'all can talk and resolve this thing afterwards if you choose to, but that's up to them. They don't have to keep you as a tenant. They have the right to have you evicted if that's what they choose to do. They don't have to take less than what the judgment is for, but y'all can talk and y'all can possibly work this thing out. But I'm going to grant judgment in favor of the plaintiff for the possession, back rent, attorney's fees, and any post-judgment interest. So, all right. And I think there is an order in the queue for me to sign. I'll get that signed as soon as I see it.
Thank you, Judge.
Good luck, y'all. Thank y'all.
Thank you.